The Trump administration was just hit with a massive lawsuit for giving Elon Musk access to the payment system used by the Treasury Department to make trillions of dollars in transactions. The lawsuit was filed under the Privacy Act of 1974 and essentially alleges that, by Scott Bessent, the Treasury Secretary, granting Elon Musk and Doge-affiliated individuals access to the payment system, the government has exposed millions of people's private social security data, medical records, and other confidential information. According to the complaint, this unauthorized sharing of sensitive data constitutes the biggest and most egregious unlawful breach in the history of the United States. At the heart of the lawsuit is the allegation that the Treasury Department, an agency that is supposed to protect American citizens' financial and personal data, breached its statutory duty by providing a private party with unfettered access to its highly sensitive databases. The complaint asserts that Elon Musk, or anyone of his caliber, should never have access to this kind of information. The fact that former President Donald Trump's administration and Treasury Department Secretary Scott Bessent permitted this access is described in the filing as the most egregious unlawful act imaginable. The suit calls for several remedies, including an injunction, a court order barring Elon Musk and any Doge-affiliated individuals from accessing sensitive financial and personal data in the future, data return and sealing, the return of any data that may have already been provided, along with the creation of a secure mechanism to seal off this data from Musk, Doge, or any unauthorized party, legal and systemic reforms, a declaration that these actions are unlawful, and the institution of measures to prevent any recurrence, ensuring that government systems adhere strictly to federal privacy laws. The lawsuit emphasizes that we are dealing with highly classified, compartmented information. While Elon Musk is known as an oligarch and is currently the richest person in the world, his personal wealth does not entitle him to access your confidential data, medical records, or social security information. Regardless of political beliefs or affiliations, every citizen deserves assurance that private data remains private. The Privacy Act of 1974 is a foundational law intended to ensure that federal agencies handle personal data with utmost care. Under this act, any agency that collects information about individuals must adhere to strict standards concerning access, use, and disclosure of that data. The act was a response to growing concerns in the 1960s and 70s about government overreach and the need to balance administrative efficiency with individual privacy rights. Legal analysts have noted that the Privacy Act was designed to establish clear boundaries around how data is shared. The unauthorized release of personal information, whether through internal negligence or deliberate decision-making, has long been viewed as a violation of the Act. In this lawsuit, the plaintiffs argue that by providing Elon Musk and Doge-affiliated parties with access to sensitive data, the Treasury Department has flouted these established legal protections, thereby undermining public trust. According to the lawsuit, the sequence of events is as follows. First, initial request and rebuff. Elon Musk and individuals associated with the Doge cryptocurrency movement sought access to the Bureau of Fiscal Services records. Initially, their request was denied by the employee in charge of the system. Second, dramatic change in policy. Within a week of being sworn in as Treasury Secretary, Scott Bessent allegedly took unilateral action by placing the responsible civil servant on leave. Immediately thereafter, he granted full access to the data to Musk and his affiliates. Third, lack of transparency. Notably, this dramatic shift in policy was not accompanied by any public announcement, legal justification, or adherence to the proper procedural protocols required for altering agency disclosure policies. Fourth, the whistleblower's role. The breach came to light only after a whistleblower, the very civil servant who was dismissed for resisting the change, revealed the unauthorized data access. Had this individual not come forward, the alleged breach might have remained undiscovered. This chain of events suggests not only a violation of federal privacy laws, but also a systemic breakdown in the checks and balances that are supposed to govern data handling in federal agencies. The lawsuit contends that the scale of the privacy intrusion is both massive and unprecedented. Millions of Americans, by virtue of their routine interactions with the federal government, have no choice but to have their sensitive information maintained in government records. This creates an inherent vulnerability. If the systems protecting that data are compromised, the breach could affect a vast portion of the population. Secretary Bessent's alleged actions, which granted Musk and Doge-affiliated individuals full, continuous and ongoing access to this information for an unspecified period, leave retirees, taxpayers, federal employees, companies, and virtually every American without assurance that their personal information is secure. Moreover, the decisions were made in secrecy. This lack of transparency means that individuals have no idea what information is being shared, with whom, or how it might be used. The potential for misuse is enormous. For example, leaked data could lead to identity theft, financial fraud, or other forms of cyber exploitation that could devastate individuals and families. This is not simply a matter of bureaucratic oversight, it is a critical issue of national security and personal privacy. The lawsuit outlines a series of specific remedies that the plaintiffs are seeking. Declaration of unlawfulness. The plaintiffs ask the court to declare that the Treasury Department's decision to grant access to Elon Musk and his affiliates is unlawful under existing privacy laws. Injunctive relief. The suit calls for a court order, injunction, that would immediately stop any further unauthorized data sharing. This injunction would serve as a preventive measure, ensuring that similar breaches do not occur in the future. Data security measures. The lawsuit demands that any future disclosure of individual records must be conducted strictly in accordance with the Privacy Act, the Internal Revenue Code, and the applicable System of Records Notices, SORNs. SORNs are legal documents that outline how government agencies manage, maintain, and disclose data, compensation for costs and legal fees. Given the gravity of the alleged violations, the plaintiffs are also seeking compensation for the costs incurred in bringing this lawsuit, as well as reimbursement for attorney's fees, additional relief as deemed appropriate. The suit leaves the door open for any further relief that the court might consider necessary to ensure that such privacy violations do not recur. To better understand the significance of this lawsuit, it is useful to compare it with previous cases of government data breaches and to examine research findings on privacy law and cybersecurity. The Privacy Act was enacted at a time when the federal government was expanding its administrative capabilities. The law was intended to strike a balance between the government's need to collect information and an individual's right to privacy. In recent decades, however, the rapid expansion of digital technology and data analytics has posed new challenges. Scholars have noted that the original framework of the Privacy Act is being tested by modern data practices that were unimaginable in the 1970s. Research published in journals such as the Journal of Information Policy argues that any deviation from the statutory protections of the Privacy Act undermines its core purpose and endangers public trust. Data breaches in the government sector are not unprecedented. Reports from the Government Accountability Office and the National Institute of Standards and Technology have documented numerous instances where sensitive personal information was improperly disclosed. These breaches have sometimes resulted from outdated cybersecurity protocols, human error, or even deliberate policy changes, much like those alleged in this lawsuit. Academic studies in the International Journal of Cybersecurity have examined the long-term consequences of such breaches, noting that they can lead to identity theft, financial loss, and a sustained erosion of public confidence in government institutions. For instance, a high-profile breach of the Office of Personnel Management in the United States exposed the personal data of millions of federal employees. That breach led to widespread calls for improved cybersecurity measures and legislative reforms to better protect government-held data. In many ways, the current lawsuit echoes these earlier incidents by highlighting systemic vulnerabilities that have persisted despite advances in technology and policy. Internationally, the European Union's General Data Protection Regulation has set a high standard for data protection. The GDPR imposes strict guidelines on how personal data must be collected, processed, and shared, with severe penalties for non-compliance. Comparative studies published in journals like the Comparative Law Review have shown that the stringent controls of the GDPR have significantly reduced the frequency and impact of data breaches in EU member states. These international models provide valuable lessons for the United States. Implementing similar rigorous standards could not only prevent future breaches, but also restore public confidence in government data practices. Recent advancements in cybersecurity have brought to light both the potential and the challenges of protecting large-scale databases. Studies from leading institutions such as MIT and Stanford University have emphasized the importance of robust encryption, continuous monitoring, and regular system audits. In an era where cyber threats are constantly evolving, it is critical that government agencies implement state-of-the-art security measures to safeguard sensitive information. According to research in the Journal of Cybersecurity and Information Integrity, even minor lapses in cybersecurity protocols can have cascading effects, potentially compromising the personal data of millions of citizens. This body of research underscores the plaintiff's concerns regarding the risks associated with granting unfettered access to highly sensitive data. In light of the concerns raised by the lawsuit and supported by extensive research, several policy recommendations have emerged. Enhanced oversight and accountability. Establishing independent oversight bodies to monitor data access and ensure strict compliance with the Privacy Act. Such bodies could serve as watchdogs, ensuring that any deviation from legal protocols is quickly identified and remedied. Transparent decision-making. Requiring that any significant changes to data access policies be accompanied by public disclosure and subject to congressional review. This would help prevent secretive policy shifts that undermine public trust. Stricter penalties for violations, implementing harsher penalties for unauthorized disclosures of sensitive information. This measure would serve as a deterrent, ensuring that government officials and agencies take data protection seriously. Investment in advanced cybersecurity. Increasing funding and research into next-generation cybersecurity technologies, including artificial intelligence and machine learning systems designed to detect and thwart unauthorized access in real time. Collaboration with private sector experts. Engaging cybersecurity professionals from the private sector to develop best practices for securing government databases. Public-private partnerships can be instrumental in sharing expertise and resources. Data breaches have far-reaching consequences beyond the immediate financial or legal ramifications. Surveys by institutions such as the Pew Research Center have shown that American citizens are increasingly concerned about data privacy and the security of their personal information. When the government, an institution that is supposed to protect its citizens, fails to secure personal data, the resulting loss of trust can have profound societal implications. Citizens may become more reluctant to share necessary information with government agencies, which in turn could hamper the efficiency of public services. Moreover, breaches of this magnitude have the potential to exacerbate issues such as identity theft and financial fraud, ultimately affecting the lives of millions of individuals. A recurring theme in discussions about government accountability is the critical role of whistleblowers. In this case, the breach was exposed not by an internal audit or public disclosure, but by a courageous civil servant who was fired for resisting the unauthorized data access. Whistleblowers have historically played a vital role in bringing attention to government misconduct, despite the personal and professional risks involved. Their actions not only shed light on unethical practices, but also often lead to significant reforms in policy and procedure. The current lawsuit thus stands as a testament to the importance of protecting whistleblowers, ensuring that they can report misconduct without fear of retaliation. Historical case studies of government data breaches provide important context for understanding the current situation. For example, the aforementioned OPM breach is a stark reminder of the consequences of failing to adequately secure personal data. In its aftermath, numerous legislative and policy reforms were proposed, although many experts argue that significant vulnerabilities still remain. Legal scholars have consistently pointed out that when government agencies deviate from mandated disclosure practices, it not only violates the law but also undermines the social contract between the state and its citizens. These precedents reinforce the argument that the alleged actions in the current lawsuit are not isolated incidents but part of a broader pattern that calls for urgent systemic changes. It is important to note that the controversy does not stop at the technicalities of data access. Elon Musk, a figure widely recognized for his role in several high-profile technology companies, has a public persona that further complicates the matter. Musk is known for his unorthodox views and controversial public statements. Recently, for example, he has been vocal about his belief that white South Africans are being persecuted for their race in their home country. He has further argued that white South Africans are being treated unfairly, and has even suggested that we should allow more white South Africans to immigrate to the United States, explicitly excluding South Africans of other races. Such statements have added a layer of political and social controversy to the data breach allegations, fueling debates on whether private individuals with polarizing views should be granted access to sensitive government data. The implications of this case extend well beyond the immediate legal battle. If the plaintiffs succeed, the court could set a significant precedent that reinforces the need for strict adherence to privacy laws within all federal agencies. Such a ruling could prompt a review of existing protocols, a comprehensive review and overhaul of how federal agencies handle sensitive information, ensuring that any access granted to private parties is scrutinized under the highest standards of data protection. Increased transparency in decision-making. More stringent requirements for public disclosure whenever there are changes to policies regarding data access and sharing. This could help rebuild public trust in government institutions. Stronger legal protections. Enhanced legal protections for whistleblowers and stricter enforcement of penalties for violations of the Privacy Act and related statutes. Broader policy reforms. Discussions on whether the existing legal framework, which was largely designed decades ago, needs to be updated to address the modern challenges posed by digital technology and cybersecurity threats.